Welcome to Life, Death, and the Law, presented by the law firm of Deason, Garner, and Hansen, hosted by attorneys Shawn Garner and Adam Hansen.
Welcome back to Life, Death, and Law. I'm attorney Adam Hansen. I'm in the studio today with my partner, Shawn Garner. I've got Tom Sparks with us. We've got Cody Beeson as well. And prior to coming on and speaking to you, we got into this discussion about what we were talking about was The Little Mermaid. It's Tom's favorite movie, right,
Yeah.
Tom?
It's my kid's favorite movie.
Okay. That's not what you said offline, but that's okay. You love The Little Mermaid, that's okay. But it came up because The Little Mermaid was based on, Disney's rendition of it was based on the actual story by Hans Christian Andersen, a Danish author who came up with a lot of different things. In fact, Frozen was another spin-off of Hans Christian Andersen. I think it was The Ice Queen was the name of the original story that Disney played off of to do Frozen. So the question became, how long can you use something like Ariel without infringing on copyright? Like, can I go and make my own cartoons of Ariel? I get really good at drawing her, and I do my own renditions of what I think she should be doing and talking about, and put that on YouTube. Would I be slapped by Disney with a lawsuit of copyright infringement? What do you think, Tom?
I think so. I think that the story and the characters are in the public domain. You can use them, but a red-haired Ariel mermaid, likely protected under the current law of copyright for Disney. Like, the more detail-oriented you get with the character, the closer you are to infringing. But the fact that there's a Little Mermaid is a open domain idea. You can recreate the Little Mermaid, but if it looks like Disney's Ariel, is the original mermaid even called Ariel in the original folktale?
I honestly, I haven't read the original. I don't know.
That's kind of what I'm driving at. Is she's got red hair, she's got the same color fin, her name's the same. You know, we have a talking seagull, for example. Like, those things are getting closer to infringement.
Years ago, do you remember this on American Idol? As part of like their special episode, they brought in the king, Elvis, in hologram form. Like, they somehow projected him in hologram form. He looked like he was there. They had cleaned up the image, and then I think it was Celine Dion that came out and sang with Elvis. I can't remember. It was a female artist. She came out, and it was a big deal to see like the hologram of Elvis be there in the flesh again. And so, how long can you use Elvis's image without?
Or how long can't you use it?
Yeah, I guess the question is, do I have to ask permission from Elvis's estate to use his image?
Well, here's what Google says. The term of a copyright for a particular work depends on several factors, including whether it has been published, and if so, the date of first publication. As a general rule, for work created after January 1st, 1978, copyright protection lasts for the life of the author plus an additional 70 years. For an anonymous work or work done under a pseudonym, work made for hire and copyright endures for the term of 95 years from the work or for the date of first publication, or 120 years from the year of its creation, whichever expires first.
So what's that mean in layman's terms, Shawn?
So you can't use somebody else's image without their permission for 120 years.
But what if they're dead? What's Elvis going to do about that?
It's still, Elvis is dead, but his image isn't, and his estate owns his image and his likeness. And so you have to get permission. He hasn't been dead for 120 years, so I say you have to get permission from his estate, probably pay them a royalty, and that I would assume American Idol went through those legal barriers to get that accomplished.
Yeah, absolutely. And I think we saw this recently as well. Tom, you're bringing up the Star Wars franchise, these last movies. In the midst of the last three that they were doing, Princess Leia died in real life.
Mm-hmm.
And so they ended up using CGI to put her into some of the movies after that.
Yeah.
And General Tarkin, I think was his name.
I think that's his name. Yeah, Carrie Fisher passed away. And while Disney owns the character Princess Leia, they don't own Carrie Fisher's likeness. So they can continue to put Princess Leia in the movies, but if they wanted to look like Carrie Fisher, then they need to go
Get permission from the estate.
from the estate.
So, Shawn, we were talking. Oh, Cody, what did you have to say?
I mean, I don't want to throw us off, but at what point does the likeliness or that look cross over? Like, at what point do we say, no, that's a cartoon, that's digital, that's not her, that's just a character we created, we don't want to pay? At what point do you get to call that?
Yeah, it's a good question. Remember Kim Kardashian was one of the first people to trademark her appearance. And the question becomes, well, if we get somebody who looks a lot like her and we put her on a commercial to market our, let's just say makeup, for example, do you need to pay Kim Kardashian? It's clear what you're doing. You're trying to find her doppelganger. Is that how you pronounce it, right?
Yeah. Twin.
Okay.
Yeah.
Trying to find her twin so you can market it and try to steal from her fame, I suppose.
That's funny that you say that. I recently met with some friends, and their daughter is like a director. What do you call that? Assistant director or something on film sets. And she recently did a film with Lindsay Lohan as the star. And they were saying how Lindsay Lohan acted on set was, probably what you would assume she would act like. But she had like 4 to 5 stunt doubles. They weren't doing stunts. They just did all of her scenes that wasn't the front of her. So literally...
Because they're so tired of working with Lindsay herself.
I don't know why they did it, but she would literally... They said she would come in. If it was a forward-facing shot of her face, she would read the line. Even if the director said, let's do that again, she'd be like, no, that's good. One's enough. And then go back to her trailer. And then the rest of the stunt doubles do everything else. So it's interesting that you bring up these likenesses. And Kim Kardashian, this conversation actually came up because, Shawn, you brought up, we were talking about AI and this new foray into this new technology that the world's kind of bracing itself for. We've got Congress trying to slow it down, and we've got the private marketplace trying to speed it up and jump right in. And there's a lot of questions. Is this going to replace a lot of people? Software engineers are super scared right now. They say, well, we don't need lawyers anymore. We don't need software engineers.
Yeah.
We don't need accountants.
The finance industry.
Yeah. So is this true or not? I mean, my experience with AI is that, no, we're not to that level yet.
Or even Google, the internet in general, right? You can get the basic information that you need. YouTube, you can YouTube almost anything, how to get it done. But at a certain point, you're going to need an expert who's done it before to actually put it together. I could YouTube how to tear apart my transmission of my BMW. I'm not going to do that because I don't have the tools. I don't have the know-how. Like, doing it over and over and over again and having that experience, there's no replacement for that. You can know how to do something, but doing it is not necessarily recommended. And I think that comes into play with ChatGPT and all the other AI options that we have out there. Okay, they can tell you how it should be done, but does that mean I ought to do it without the help of an expert? That's the question.
So do you think that the intellectual jobs would be phased out first, and then there'd be a turn back to blue-collar work?
I quite honestly don't. I think what it's going to lead to is that people need to up their game as far as qualified workers and using AI. I think it's just another tool in your tool belt. For example, I don't think the invention of steel put the woodworker out of business. It just put working with wood out of business. It put the woodworker into a new area, new industry of business, and that is forging steel.
Mm-hmm.
Yeah, in the AI world, I mean, it's not magic. An AI bot does not understand. It's kind of, I think of it like an infant. You have to train it the way that you want it. The challenge with today's publicly available iterations of AI, like ChatGPT, or you've got Gemini from Google. It used to be Bard, and then Microsoft has its own version of Copilot.
What? Is it Copilot Microsoft uses?
Yep, Copilot.
And so each one of these is kind of like a skin on top of what's called an LLM, a large language model, and that's the basis or the code that's being that is driving the conversational tone when you're talking to an AI bot. That thing can learn. It is learning, but what you feed it is going to make it learn the way that you want it to. And so when we're using these publicly available bots, they've already come. By the time we've used them, I mean, they've already been beta tested. They've already been saturated from that company itself, be it Microsoft, Google, or ChatGPT, which is OpenAI, is the basis of that company.
You're getting a highly biased opinion.
Absolutely. And we talked about this when, what was this, maybe a year ago when I started playing around. We were playing around with it, and we were getting all sorts, like anything conservative was being...
Yeah.
Remember, tell me a joke about Muhammad? I can't do that.
No, yeah.
Right.
So
Yeah.
is that good or bad? I don't care. It is what it is. And so I have already a built-in skepticism of using one of those public forums to ask it questions, knowing that it's going to come through a lens of what those developers have decided.
You remember the
is
question
moral
we
system.
tested it with?
It was something about Biden and Trump.
Yeah, we asked, why was Trump the best president? And it said it couldn't take political stances and it couldn't make opinions on those issues. And then we asked, why is Biden the best president? And it gave us this big, long list of all these accomplishments that he had done throughout his career. I was like, oh, well, I guess that's a little double standard.
Mm-hmm. And so is it it's drawing off of things that has been fed. So it's kind of like raising a child. You know, if you feed it junk its whole life, it's going to grow up thinking that's the correct moral compass. So anyway, this whole conversation came up because Shawn was like, let's talk about AI today. And I said, no, I don't want to talk about AI.
You're working with AI.
I am working with AI.
As we put on this show.
It's
and
my secret project that I didn't want you to talk about.
Well, so here it is. Here's the thing that is interesting, that is new about AI. And everything's new. Every week that goes by, something new comes out. And LLMs was something new that I was actually fooled by. I said, well, okay, first of all, what are LLMs? And you described it just shortly ago, but say it again slower so we can understand. What's an LLM? Because that's what everybody's talking about now.
LLM stands for Large Language Model. That's the base or the code that is the basis that you start with to create an AI program or bot.
So it's not a variation of an LLC.
No.
Yeah.
Because that's what whenever I saw
It's
LLM,
not a legal master's either.
Yeah, it's not exactly.
Yes,
In
and
tax or something. No,
people have LLM after their name, and that means they're a master in tax law.
It's a generic acronym that we use for ChatGPT, Gemini, OpenAI system, or Copilot from Microsoft.
That
It's
has
an
come
LLM.
into our parlance in the past 3 weeks, basically. At
So
least.
those are all public ones that I just mentioned, but there's private ones. People, the geeks around the world have been going off and creating all sorts of
Speaking
what
of.
do you call branches, so that you can download and you can have those privately and run your own stuff.
Speaking of
without
geeks
bias.
around the world, there was 2 that I ran into last week that had big grins on their face on separate days. And I was like, what are you so happy about? One had this big box in his hand, and he said, I got my own AI, LLM. And I was like, what the heck? Why do you need your own? You got ChatGPT, you got all the others that are free out there. Oh no. Oh, those are fed with, what they want to indoctrinate us with. I'm going to feed this one. I'm going to train it up to do what I want it to do. And I said, okay.
What a nerd.
And then I went back to work in my office doing real adult stuff.
Yeah, that's why I was reluctant to tell you what I was working on.
But so anyways, I
Because
saw.
I get no respect around here.
Well, I was going to put on an LLM explanation.
And I told you this was highly confidential.
Yeah, nobody listens to this show.
That's true. That's true.
So now my mom knows about it, but other than that, we're okay. But so Ryan Gosling is out there describing LLMs, and I'm like, I wonder how they got
Like
right.
it was a video that you found. You said,
Yeah.
look, Ryan Gosling is even... I said, nobody's talking about it, Shawn. He's like, look at this. Ryan Gosling is
He's
talking
out
about
there
this.
on it. If
The
Ryan knows
Gosling.
about it, yeah.
I was like, yeah, that's a deep fake. That's not real.
And so let's talk about that a little bit. With AIs now, you can do these deep fakes of any individual that you want, talking in their, nice, subtle tone and having their nuances and their beautiful image, describing what it is that you want to learn about. And so it can make learning a lot more entertaining. I'm sure my daughter is much more apt to listen to a math teacher that is looking like Ryan Gosling than what her current... I'm sorry, I don't know what her current math teacher looks like.
You're assuming that was the biggest assumption.
Gosling's older brother teaching calculus in Yuma.
Yeah. So, but yeah, Ryan Gosling, you could look up what is an LLM and how do you use it, and you can have it explained to you by Ryan Gosling. And I was going to play that, but by this point, we're kind of beyond that. But LLM is your own personal. You can download this large language model, and it can explain to you how to use it so you can put in your own information, and then it continues to learn from the information that you upload into it.
So this all circles back. We got to go to break, but this all circles back to what we started with Tom's favorite movie, The Little Mermaid, because the question becomes, okay, now we have this deep fake of Ryan Gosling that was created by AI. It looks exactly like him, sounds just like him, and it's not him. And so now does he have a legal remedy to go after the people that published that video and say, that's not me. I didn't give you permission to use me or act like that. I didn't say that. Where are we now in the world where we've got to actually protect our physical image and our speech in the sense of policing companies or AI companies that are allowing this to happen? We got to go to break. This is Life, Death, and the Law.
You're listening to Life, Death, and the Law, presented by Deason, Garner, and Hansen, the law firm that has been voted Yuma's best 6 years in a row. You're listening to Life, Death, and the Law, presented by Deason, Garner, and Hansen, the law firm that has been voted Yuma's best 6 years in a row.
Welcome back to Life, Death, and the Law. I'm attorney Adam Hansen, and we've got my partner Shawn Garner. We've got Tom Sparks in the house, and we've got Cody Beeson. We've been talking a lot about the new foray into this AI world that we're living in. Shawn had found this video about Ryan Gosling explaining AI and large language models, LLMs, and
I just stumbled upon Ryan Gosling. I was actually looking up AI stuff, just to be clear on that.
yeah, right. Okay. And so anyway, he found this video. He's like, look, even Ryan Gosling is talking about it. I said, I've seen that video, and it's fake. It's a deep fake.
I didn't
It's
know
to show what
that.
AI can
These
do.
guys all publicly shamed me for believing that it was actually Ryan Gosling. I actually believed it was him.
Really?
Yeah.
Right off the bat.
I'm pretty gullible, I guess.
Yeah. I mean, those two just didn't
I'm
go.
like, dang, Ryan
I
Gosling really
would've
upped his
believed-
game. He sounds really smart on this video.
I would have believed it to be Ryan Reynolds. Reynolds is actually really smart.
Yeah.
And a
But look
great
what
businessman.
we're doing here. We're
I mean,
saying
if it's
that,
Matthew McConaughey explaining it, then I might have had a little bit of doubt.
but
But
none of those
all right,
observations
all right.
matter about their look. Like
What
it looked
do you
like Ryan.
want?
Yeah.
what do you want? That's the only thing I know about
That's
Ryan
copyright.
Gosling.
Yeah, that's The Notebook.
Yeah. If
Sean's favorite movie.
if
Tom
you-
loves The Little Mermaid. Sean's got The Notebook.
I only know that because I use it every day when I'm trying to figure out what my wife actually wants.
Gotcha.
Okay, sorry.
I
Tom.
was just gonna say that the video looked like Ryan Gosling. It sounded like Ryan Gosling. The only reason we didn't think it was is because it didn't make sense for him to be talking about AI, which just shows you how powerful it is. So, if you don't know who Ryan Gosling is and you think that maybe he has reason to know about AI, you wouldn't know it was fake.
Yeah.
They're getting too good.
Speaking of, like, what rights do we have to use other people's intellectual property or their likeness and their image? I want to talk a little bit about the copyright. Copyright protection is good for, I think it's 10 years. Yeah. Sorry, no. The copyright was for 70 years from the life of the author, or 120 years from its creation, whichever is longer. Then we get into trademark. And so trademarks are, like the Safeway symbol. You get
McDonald's.
Yeah, McDonald's symbols, those types of symbols, those are trademarks. Those are good for 10 years, but you can renew them. So they can be good indefinitely because the companies that have vested interests in them, they want to renew them every 10 years. And so McDonald's, it's going to go on in perpetuity. And then we've got the patent. And this is where it got a little heated here off the air, and we almost came to fisticuffs. But we restrained ourselves, and the patent is
Almost
good
dueled.
for, right?
It took the shirts off and everything.
Yeah, only 20 years. And it's really interesting because there's some significant events in human history where I think the expiration of the patent actually saved literally the innovation itself. for example, the Wright brothers, they were able to patent the right to fly. Not their design of the airplane. It was flying in general. They were able to win that patent. And then along came World War I, and the United States said, okay, we have an overriding security interest here, so we're going to limit that right to your patent, and and it was an individual named Carter, I forget his first name, that he figured out a way to fly much more efficiently with a fixed wing plane, and they allowed his invention to come in and be produced without paying the massive royalties that the Wright brothers wanted. In fact, the Wright brothers were really kind of
Jerks.
when it came to their invention, they didn't want to allow it out there. And in fact, they blamed Carter for the death. And I forget if it was Orville or what's the other Wright brothers' name?
I don't know.
Come on.
Anybody?
Uncultured swine.
Bueller.
Okay.
I don't know it.
We're looking this up.
Wilbur.
Wilbur.
And Orville
knew
Wright.
that.
Okay. So one of them passed away as a result of the stress that they were going through these lawsuits to protect their patents and protect their right to fly. And you think about that, that's really selfish that they didn't want the rest of humanity to participate in this wonderful invention that they came up with, or it wasn't even an invention in and of itself, but the ability to fly. And another invention was a television. And so when the television was invented, there were a lot of patent lawsuits about that. And then what happened was World War II came around about that same time. Nobody could afford a television. The individual was this young kid from Idaho. I'm going to get his name here. Philo Farnsworth. He invented the television, and he was this young kid out of southern Idaho. He didn't have a lot of backing, but it was RCA that wanted to develop the television. They just couldn't get it right, and so they went and they copied his work, and they were able then to get it right, and he sued them for patent infringement, and after years in court, he won. And so they couldn't develop the television. And then World War II ensued. Nobody could afford a television. After World War II, guess what? The patent that he was given, awarded the right to, had expired, and RCA comes out starting developing televisions. And Philo died without anybody knowing who he was, and penniless and alone. So is that good? Is that bad with the patent laws? Should they last longer? Should they not be enforced at all? That's the argument that we're putting out there. And Thomas, what's your position on that?
I think the patent law has a place. I just don't like the idea of a monopoly. So essentially, a patent will give you a monopoly on the product for 20 years. And what I think should happen instead would be you can get a patent, but instead of you being the sole individual who can develop this, and you can limit who can work on this type of technology, I think they develop a more robust royalty system, so we still have competition in the marketplace.
Well, the royalty system currently, if you own the patent, is whatever you want.
But if you own the patent, can you deny production?
Yes.
So that would
for the
be
20 years.
So that would be, I think, the thing that goes too far. Like, I don't want 20 years where you deny production.
That they say, okay, you can charge a royalty up to say 50% of the cost of production, and so or the profits or whatever revenue is received from producing and selling, marketing your product. But over that, we're going to limit it because we want the people to be benefited from whoever can market it and get it out to the masses the quickest.
Yeah. Nope. I think maybe a sliding scale of royalties.
What do you think about that, Adam?
Well, as you're talking, I was thinking about using a person's patent to basically building upon a person's patent. And how does that work? Obviously we're not patent attorneys. Those guys are incredible. They usually have to have a degree,
a biology and a chemistry or some type of,
or mechanical engineering a lot of times, and then you go to law school on top of that, and then you have to pass not only the bar for law, but then you have to pass the patent bar, which is like even harder. So patent attorneys are incredible, and so we're not holding ourselves out to be patent attorneys at all. In fact, we barely even dabble in that area in law school. They give you a little taste of it, but it's pretty assumed like, okay, you guys aren't going to be patent attorneys, so here's a little bit so you know enough to be dangerous, but the real patent attorneys are going to come to the top here, the cream of the crop. But having said that, I've always, you were talking about restriction on use, Tom, and how you disagree with that. Meaning, if I invent something and my invention is incredible and you want to use it, you don't think that I have the ability to say, no, you can't use that. I created that, and I'm denying you the ability to use it because I own the rights to that.
No matter how much Tom is willing to pay you out of the profits that he makes from it.
Right.
I don't even think that's very common. I think you might have the right to do that, but I think it's more common for people to license the right to use it. So I get to use your product. I can't copy it. That's really what patent law is about, is copying it and then selling it for money.
Yeah, as if you invented it
As
yourself.
if you invented it.
But what if you had a scenario where somebody found out how to make an identical product, but they made it way cheaper than you could? Like, their process is way more efficient.
Well, they're always doing that.
And that's
Like
what
China does.
That's what China's doing.
Yeah, that is what capitalism is in a sense. It's
True.
who can make the product the most efficient and provide it to the consumer in the easiest way, and that person wins out.
In fact,
where does patent law come into that? And
I was just going to say, in fact, I kind of rely on that capitalistic system.
Sorry.
For example,
Playing
you
footsies with Tony.
you have these really nice sheets that are the newfangled sheets or mattresses. You see these things all the time, and they're exorbitant amount of money to buy them. If you get the one from that company, I know that if I wait 6 months, I'm going to find it on Amazon from some knockoff.
Yeah.
It's going to feel exactly the same. It's going to look the same, but it's some knockoff company, probably from China or some sort of merchandise coming in from China. So I kind of rely on that. I just wait. I play the waiting game. Okay, I really want that product, but I know if I wait long enough, I'll find it on Amazon for cheaper because somebody's going to do a knockoff. Is that always the best thing? You know, I mean, when I do that, I know I'm probably going to get a little bit downgrade of quality, but some of these knockoffs, like we talk about AirPods, you can find some really good, they look identical to AirPods. They sound a lot like AirPods. You know, it's like they get really good at copying things.
I didn't know that. If I had known that a week ago, we could have averted some huge battles in my family.
Oh, there you go. I just don't want to wait 20 years.
Well, here's my argument for the patent. It takes a lot of time and initial investment up front where you're not getting compensated. You're taking this out of your personal life. Generally, it's not your full-time job to develop this product or this idea, and it's intellectual property that is being protected in the patent. And if we don't allow that to be protected and that ownership, number one, is unconstitutional because we have the right to own property, including intellectual property. So I think that is infringing upon your constitutional rights. Number two, it disincentivizes people who would put all the time and energy into creating better products that improve our everyday life. And we want to incentivize people to continue to improve. We want the drug companies to continue to innovate to make our life better. And so they get to capitalize on those innovations for a limited period of time. And the law has come up with 20 years as far as that limited period of time. Now we see where they don't honor those laws, like in China, and they infringe upon patent and copyright and every other law, and you get these movies that you're not buying from the actual producers, and it cheapens the whole product, and it also creates a disincentive for the artist or the inventor to put in the hard work to do it again.
Patent law, though, you just mentioned China. I mean, the thing about what we're talking about, it's United States law.
Yeah,
it's not
right. China doesn't have
law.
to abide by it.
But they do have every country has their own patent laws or IP laws, intellectual property laws. But you as an inventor, you would have to be very diligent about going to those countries, those foreign domains where you think it might be used, or you're going to sell it, and you have to take out you have to copyright or you have to patent it over there as well, because they don't care about American law or U.S. law. Excuse me. They don't care about what's going on here on our turf as far as an invention. So I think China is a lot. They don't really care. Like it was created over here in the United States. We might have some patent laws or copyright laws. They don't care. They're not subject to the United States copyright laws or patent laws. They're subject to their own laws, but they might not have that in their own forum.
Yeah.
I think that I agree that patent law, there's a place for it and that we need it. And if you don't protect someone's interest in creating, then people are going to stop. Like, why would I waste my time creating something if this big company is just going to steal it out from under me and do it way cheaper?
Mm-hmm.
But what I think the protection is just too robust. The protection is I can prevent you from making this cheaper and better for everybody, and I can force my inefficient process on the public if I so choose.
Yeah.
And I don't want that option.
However, human nature generally isn't like that. I don't
Right.
believe it is, at least.
I don't think we should rely, though, on the human nature to save us. I think the law should just protect it.
Well, the law does, in a sense, 20 years.
It does, but I
And
think
so,
it could be
like,
better.
if you can come up with your own way that is not this exact patented way to do it, then go for it. And you get your own patent. But if you can't, then within 20 years, then you can use that person's invention. There's a wonderful movie out there about this. It's called Flash of Genius. And it's about this individual. His name is Robert Kearns, and he invented the intermittent windshield wiper. And Ford had been working on this for a long time, and so had GM and some other these major companies, and they hadn't been able to get it down. And so he developed this, and he was a tinkerer, and he was an engineer. He taught engineering in school, and made a decent living, but struggled from day to day to provide for the family and make ends meet. So he's working all through the night to make this intermittent windshield wiper, and he's very cautious when he presents it to Ford because he doesn't want them to steal his idea without compensating him. And his agreement with them is that he's going to be able to manufacture it. He doesn't want them manufacturing it because he feels like if they can manufacture it, then they have to have the actual design. He says, I'll manufacture it, and then you do your quality control, put it in your cars, and you can go ahead and do it for the next 20 years. So Ford agrees to that, and as soon as they get the first model of it, they reverse engineer it, and then they tell him, oh, we no longer need your contract. We're going to go ahead and cancel that. We're going to do it on our own. We figured our own way out how to do this. And this guy dedicated his life, and it ruined his family life. He got a divorce. He put all of his time and energy into suing Ford for this. They came up with several settlement offers to pay him off and just get him out of their hair. He ended up just going through for moral issues, and he won tens of millions of dollars against the Ford Motor Company for doing this. I agree with him, and I'm glad there are people like him out there. Of course, I would never have done that on my own, throw away my family and everything. But there are those that need to take a stand up against the big guys that already have everything and say, no, I created something. If you want it, you got to go through me to get it, and you got to pay my agreed upon royalty fees.
Yeah, I think I wholeheartedly agree that as long as it's a royalty fee, that's the remedy and not an injunction.
But if you force a royalty fee, then you are also infringing upon another constitutional right, which is the right to contract. And my right to contract is I don't want to give you a royalty at all. Or I don't want to accept a royalty agreement from you.
Yeah, but we're also making up the right to the patent. Like the 20-year right to a patent is made up. Like I don't read that into the Constitution personally. Like just because I have the same idea doesn't mean I stole your idea. Like it's not the same thing as I stole your tangible personal property.
Well, in our world today, intellectual property is just as valuable, if not more valuable, than tangible property.
Which is why I think the law was on the books, because we recognize that there's a fundamental difference between IP and tangible property.
Right.
We got to go to break. This is Life, Death, and the Law.
You're listening to Life, Death, and the Law, presented by Deason, Garner, and Hansen, the law firm that has been voted Yuma's best 6 years in a row. You're listening to Life, Death, and the Law, presented by Deason, Garner, and Hansen, the law firm that has been voted Yuma's best 6 years in a row.
Welcome back to Life, Death, and Law. I'm attorney Adam Hansen, and we've got Shawn Garner with us. We've got Tom Sparks and Cody Beeson, and we've been talking a lot today about intellectual property law. I know that sounds boring to you, but in reality, I mean, it's touching everything you're doing today. The intellectual property law is touching everything that you're going to be involved in today. If you use your phone, if you use a computer, if you drive your car, these are all things that you open up the fridge. These things are all regulated by intellectual property law. And really, it's not like our founders didn't know about these concepts. In fact, Ben Franklin was one that was adamant about not having patents. Right, Shawn?
Yeah, well, he himself invented a lot of things that we even use still today, like bifocals. He invented those. Flexible catheters. He invented that. I mean, he was an amazing, amazing person. He invented about 10 things that we still use today, and he never patented any of it. He just gave his ideas out there freely, and I think some of the greatest ideas that he came up with was, of course, the constitutional republic. And that was an idea that we're continuing to use right now. But as far as items go, he believed that the world should benefit from his genius. And so he gave that freely. Now, with somebody with so many talents, you could downplay that a little bit and say, well, he had so much else going for him that he didn't need to patent something and become rich off that individual patent. But Thomas Edison, on the other side, he had over 1,000 patents, and he was very, very adamant about protecting his patents, and he would sue and did sue frequently for patent infringement. In fact, there's this big feud between him and Nikola Tesla about patents and electricity and what electricity was the best electricity to use, and there's a good series out there about that. But so that essentially is a great controversy that continues today, whether or not patent law should be as heavily protected as it is to provide inventors incentive to put in the blood, sweat, tears, and money up front to continue to invent and then protect their right to use their invention as they see fit for at least 20 years, or should we mandate that they allow others to use it as long as there's a reasonable royalty paid to them for their ideas. We're not going to solve that today, but one thing that I do want to get into, Adam, you brought this up, is Microsoft and Apple. It's a different issue, and the issue there is monopolies. And so right now, Apple is being sued for having a monopoly and using it in a way that is curbing market intervention or the ability for other competitors to come up with their own ideas and compete with what Apple has already put out there. For example, everybody knows that the iPhone is super popular. I think it's 7 out of 10 users in America of phones, cellular phones, use iPhones. And Tom doesn't. Who uses iPhone
See in the
here?
room. What's our ratio in the room?
I use an iPhone. Cody uses an iPhone. You use what is that, an iPhone or Android?
Yeah, reluctantly, I have to have an iPhone.
Oh, so you got an iPhone. Okay. So
'Cause my wife makes
there's
one
5 people in here.
I do not
Martin
want
is
to.
in here. He doesn't have a mic right now. But so 4 out of 5 people in this room have iPhones. And that's fine. I think iPhones are a great product. I was reluctant to move over as well. But the problem was none of the videos that I was taking and the text messages that I was doing was being integrated well with the group of people that I was communicating with. And it's because Apple very purposely made that information be downgraded in quality when it came over. For example, the text message would what did it do to the text message group text messages if somebody was an Android
The
user.
green bubble
It just
versus
show
the blue bubble.
Green, yeah.
Yeah, but it would do something else too. It would prevent the whole. So, for example, if you attached a video to it, the video quality for the entire group would be significantly reduced. So you could record something in high def, and if it was all Apple users receiving it, then it would be high def for them to watch it. But if there was a single Android user in that group, then it downgraded the video for everybody else. And so everybody's going to gang up on that Android user and say, hey, get on the bandwagon
Got
here.
an iPhone.
Yeah.
Fun fact too, that the messaging that Android uses is newer technology than Apple's messaging.
And much broader. There's the uses that are available in the Android, and I saw that as well, that there was a much broader application for those videos and what you could do with them as far as editing. But so the government right now, Merrick Garland right now, the Attorney General, is suing Apple for a monopoly. And what a monopoly is not just owning all of one product, it's using that ownership in that product to curtail the development of other products and put down competition in the market of other products. And that is what Apple is doing.
And it most likely will be successful. I'm projecting it's going to be a successful lawsuit against Apple. The reason why Apple recently included a USB-C port on the bottom of their phones was because they got sued in Europe. Europe brought a similar suit. The European Union said you're purposely downgrading the experience for everybody, and we're not going to allow that. So instead of Apple saying, okay, we're just going to change our iPhones in the European market, we're just going to blanket put USB-C ports on all of our stuff. Hitherto, they were using their own proprietary Lightning port, which is significantly slower. In fact, when they moved to the USB-C port that they were forced to do through this action, the new iPhones come with the USB-C port. So now not only do I have to have like multiple chargers to do my laptop or to my phones or my AirPods, it's super annoying, number one. Number two, those ports aren't designed for the data speeds that Android phones, for example, have been using for probably over a decade. And so even though they did substitute in now a USB-C port, even if I plug into it, it won't charge as fast, it won't transfer data as fast because they're far behind technology because they purposely did that. They were so intent on making it a bad experience for their users dealing with other people that didn't have iPhones or Apple products that it kept them way back technologically. And so now the world is really probably 15, 20 years ahead of them in technology when it comes to data speeds, when it comes to features on their phones and on their devices. And the common mantra is, I'm not coming at Apple. I could care less. I have to have an iPhone because my wife is all Apple, and so we had to go into that ecosystem because she says, it's simple for me to use, and that's true. It is very simple.
And she wants to track you with Life 360.
That's really what it's about. Well, it's not Life. It's Find My. So she wants to know where I'm at and where kids are at. So
what's Life 360?
It's an ecosystem. That's an app that works on all phones or on all systems.
Okay.
That's not good enough, I guess, for
Gotta have FaceTime.
my wife. You gotta have FaceTime.
It doesn't pinpoint you as precisely.
So Cody is chomping at the bit. He loves Apple. He's an Apple guy, and we've had these conversations.
Yeah, you've
before.
always been pushing Apple on us, Cody.
After the BlackBerry, yeah, I went to.
And this is what
Apple. It just worked.
This is what Cody, his argument is simple. He says it just works.
Yeah. What's a driver?
Yeah.
We don't have to deal with that anymore.
Yeah.
It just works.
Do you know why Apple even exists? Because of the type of monopoly laws that are currently being used against Apple with Microsoft. Microsoft had a monopoly on Windows and how it was being used, and it was crushing competition by either buying out startup companies or underselling them because it could sell its product. It was so wealthy that it could sell its product cheaper than production until those smaller companies would go out of business. And so
which is really kind of funny because they're built on, you talk about Windows and Mac OS.
Yeah.
Mac OS is built on a free system, Linux, an operating system that anybody can use. I mean, you can download all sorts of flavors of that Linux system. And so Apple just did that, and they created their own skin on that. But then they give it to us on a phone, their own mobile version of it, and they charge us $1,500 for
Well,
it.
Steve Jobs originally created Windows, and Bill Gates took it and sold it before he could. They basically were partners initially, and Bill Gates took it and marketed it at first and patented it first. And anyway, he was out there, and that goes back into the patent law. But what happened was the federal government, it's under the Sherman antitrust laws, which the name of that law makes no sense. Either way, it forces companies
Old school.
to not take a non-competitive approach to the use of their whatever product.
Yeah, absolutely.
And so when they have such an overwhelming market share of the product that they can put down all the little guys that are trying to innovate and come up with competition, then the antitrust laws come in and say, no, you can develop as much as you want, but you got to let other people develop too. You can't go out there and basically strong arm all the upstarts from having competition. And so what Bill Gates did is he lent Steve Jobs a couple $1 billion, I don't know how much it was, maybe $100 million, and says, listen, in order for me to continue as a company, I have to have competition. You are the only viable competition out there that's really going to produce a good product. So I'm going to take your fledgling company that is basically about to go on and become bankrupt, and I'm going to give you money so you can be my competition. You can be basically my little brother, so I can continue on running the world with Windows. And lo and behold, we've seen what's happened. Apple has surpassed.
The students become the master.
Though, there's no Microsoft phones out there or Windows phones out there. I mean, if there are, then
There's a few.
It's a guy living in his parents' basement, basically.
We got to go. We will talk to you next week. This is Life, Death, and the Law.
If you have questions or want to know more about something that was discussed today, please call the law firm of Deason, Garner & Hansen at 928-783-4575 or visit yumaestateplanning.com.